Hello, I'm April Jones, and we at Jones Law Firm care about you, your family, and your well-being. That's why we've put together this informative webinar series to answer your questions about life, about the law, about your family. So thank you for joining us, and let's get started.
Hi.
Hi, okay. Hi, everybody. April Jones here. This is the Jones Law Firm PC Family Law Panel. I am joined by three of our amazing family law attorneys, and today we're talking about the use of evidence in family law court, and we will be taking your questions. We've asked questions in advance, and so we have questions by attendees and questions by people who reached out to us in preparation for the webinar today. So please feel free to continue to drop questions in the Q&A if you think of anything as we move along. All right, so first we're going to go around the room and have each attorney do just a brief introduction, name, how long you've been an attorney, and then, this is different, what's your favorite type of evidence to present in court? So I'll go first. I'm April Jones. I've been an attorney over 30 years, founded Jones Law Firm in 2000, and we are moving into our 24th year, very exciting. And my favorite type of evidence to present in court, something exciting, something that the other party doesn't see coming, so that when you're asking them about it, the witness, they're like, they're saying yes, yes, no, no. And then you whip out the evidence that shows that everything they just said is not true and proves your case. So a little Perry Masony, but it does happen sometimes. All right, Billy.
Hi, my name is Billy Skinner. I've been an attorney for 17 years. My favorite type of evidence, similar to what April says, is kind of the surprise evidence or the aha moment where you have someone, and it may be through a video, it may be through a photo, it could just be through cross-examination. But when you're able to present something to the court that's really helpful to our side, that really hurts the other side.
Thank you. Morgan.
Hi, everybody. My name is Morgan Terrell. I have been an attorney for 10 years, and I would say my favorite type of evidence, similar to April and Billy, is also sort of that evidence that you can bring in that maybe the other side forgot about. I really like text messages between the parties, so they may have forgotten that they put something in writing, and then there it is.
Thank you. And Will.
Hi, I'm Will Garvey. I'm a fifth-year attorney. My favorite type of evidence is, a little bit, it can be the same as kind of what everyone said, the surprise stuff, but I like presenting the financial evidence. Really, it solidifies to the court what amounts should be divided amongst parties. It can help with maintenance, help with child support, anything of that sort. I'm a little bit of a nerd for the finance stuff myself, so I like figuring out how to present that in a somewhat exciting way to the court.
No, I like that. I mean, you can get your big bang surprise out of bank statements and evidence all the time. So one of the questions is, what is evidence? How is it typically used in a family law case? So Morgan was a public defender for a very long time. Why don't you tell us what evidence is and then how it's used in a family law case?
Sure. Evidence is all kinds of different things that we can bring in during a hearing or during any kind of court proceeding that is basically going to support our position or what we're trying to say or what we're trying to advocate for our client, right? And evidence can come in lots of different forms. Evidence can be even the testimony of the parties, right? So even testimony of wife, husband, mom, dad, whatever it is, that's still considered evidence. But it can also be things that we may think of as typically more more what we think of evidence. So like we were saying, so text messages, any financial documents, any photographs, any statements from other witnesses or anything like that, police reports sometimes. So all of that can be evidence. And we just have different rules that govern what evidence can come into a hearing and what evidence can't. So we'll talk about that a little bit more as we sort of go through today.
So then what are the most common types of evidence that we see admitted in family law cases? Billy.
Yeah, that's a great question. And we see a variety of evidence. I think Will hit on a lot of it. There's a lot of financial evidence that comes in family law cases that sometimes people don't think about it because they think about those aha moments like Morgan alluded to, text messages between the parties, maybe videos and things. But financial evidence comes in and makes a huge difference when you're dividing the estate. And that's one of the things that I think sometimes people don't see as like fancy or sexy evidence, but it really can turn a case just like that. And it can show a lot of different things about the parties, their spending habits. Financial documents can also, something that people forget is financial documents can oftentimes have character evidence involved. Because if you're a person who goes to the liquor store every day and that's in your financial statement, that's not going to look good to a court. And so there are oftentimes little things buried in parts of evidence that you don't see on CSI or television shows like that that can really be impactful in family cases.
That is true. And to just elaborate a little more, the liquor every day won't look good if you are parenting a newborn and swearing that you don't drink, for example.
Exactly.
So yeah, that's when the evidence gets to be interesting, even though it's not for finances. Now, often, obviously, finances are for finances. This is what you pay for this secret mortgage, or this is the cash you've been stashing. And you can bring statements in to show that. And you can request additional statements from credit card companies, like as you dig into the evidence that is required to be exchanged. So financials have to be exchanged in a divorce case and in a custody child support case. And so there's a whole sworn financial affidavit that asks for particular documents. Will, why don't you, I know you like that a lot. Why don't you talk a little bit about what that evidence is?
Sure. Yeah. So that evidence actually starts from the very start of the trial, or very start of the case, to be honest. One of the first things you're going to do when filing a divorce or a dissolution of marriage is prepare a sworn financial statement. That's going to be kind of a basis for a lot of the evidence that's going to come in. Along with those sworn financial statements, you're producing statements of your bank, statements of credit cards, anything that evidences your debts and assets that you might have throughout the marriage. It could be mortgage statements, car payments, anything like that. All of that can be useful at trial, especially if it looks like there's something being hidden. You can dig through someone's bank statements and look and see transfers one place to another. In the modern day, we're seeing Venmo stuff, any sort of online payments as well. You can kind of dig through that and see who's sending money to who. Often people don't disclose that, so you got to go subpoena records, and that's where you kind of get the surprise stuff that comes in. That's the exciting bit of evidence. You don't really have to turn that over until right before trial starts. So one party may think, they're pulling the cloak over your eyes, hiding all of these bank accounts that you might not know about. And then at the last minute, you get to come in and say, hey, look, these are all our subpoena responses that we've gotten. Here are these bank statements that for thousands or hundreds of thousands of dollars that weren't disclosed before that we now get to bring in front of the judge. And, we're going to use that as a cudgel when you're on the witness stand too. So that's kind of where the excitement comes in when you're introducing the evidence, is when you got the witness on the stand showing something that they didn't produce that you now have access to, and that they tried to hide the whole time. Courts really do not look on that favorably. So that's something that you get to really see how the evidence plays out in court. Normally everything is really 50-50 with assets in court. Courts will divide it pretty evenly. But if you start hiding stuff, the judges get angry and they will punish you. And that's where you start to see some of the shift in that percentage for the offending party versus the non-offending party.
And the other way you can use bank statements is just to build your case. This is what mom does over and over and over. Dad said that she doesn't, fill in the blank, doesn't take the child to the dentist, doesn't take the child to medical treatment, doesn't feed the child properly. You can just walk through a bank statement like a diary, to the point that the court says you can move on, Miss Jones, because you just really just boom, boom, just steady, steady, steady. So that might also be my favorite too. I think I have lots of favorites. And
anytime a judge tells you can move on,
yeah,
you made your point.
I get it, Miss Jones. Okay, one more. But the other thing too is, with respect to this discovery and the documents that we're talking about, that can really drive up the cost of your case. So we try to be strategic and thoughtful in how we analyze it. If it's important and you need it, we get it. If you're saying, hey, I know what he has, that's not why I hate him. I hate him because he, does this other stuff, but I'm not worried about our finances. I trust the information. He trusts me. We want to fight over whether or not it's best for him to have the children on the weekends, right? So we take the client as they come and we discuss with them what the options are, and we listen to them, and then we make really strategic decisions rather than let's just get all the documents we can and run up the cost, or don't get a document because you don't want to run up the cost. It's very strategic and thoughtful. Okay. So what would you say are the biggest misconceptions or mistakes that people have about evidence in their case? I'm going to say thinking that everything can come in just because it happened. Morgan, why don't you elaborate? And unless you have another big misconception.
No, I think that's a great one. And I think that is sort of a misunderstanding or sort of a misconception that people may have when they're not, sort of trained in how the court systems and the court processes work, right? I mean, we go to school for 3 years and then even then we don't know, all of the ins and outs of, what's admissible when and because there are a lot of different sort of pitfalls that you can fall into. And, we learn that through practice and we have experience with that, which is why it's always good to have an experienced attorney on your side because there really are a lot of ins and outs. And so I think that probably the biggest misconception is, well, I have this documented, right? I have this conversation with my kids documented, right? I have them on video saying that they don't want to go and see mom or dad, right? That's not necessarily admissible. And probably more often than not, it's not admissible. And not only that, but different kinds of evidence, even if we're turning something over to the court that we may have questions about being admissible, that may or may not really strengthen or help your case because the judge is looking at the evidence. It may not be, admitted at a hearing or something like that, but the judge is still aware if you're submitting that kind of stuff. And then the judge is going to be questioning you like, well, why are you going to these lengths, recording these children, involving them so much in the process? And so that's why it's really important to, talk with your lawyer about, well, I have this, how do we think that this is going to play? Because sometimes it really can be a double-edged sword.
And when you're so close to it because you're feeling the emotion, like I am recording my children because he is, mistreating them in this way, and it is on the recording, you're so close to it. You can't see that by forcing your children to repeat the story over and over, you are impacting them in a negative way. Like it really cuts both ways. Billy, well, why don't you comment a little bit about what hearsay is and how that keeps out a lot of the information Morgan's talking about?
I will get to hearsay, but one follow-up to what you just said is it's important to remember that the court is interested in what's in the best interest of the child. And sometimes it's easy to get confused about what we're excited about as adults and what's in the best interest of the child. So we have to be very careful with that type of evidence. Hearsay is one of the most difficult things for people to understand at times. I compare it to the rule in soccer where you can be offsides. Really hard to understand how that makes it not a goal. People often have a hard time understanding, but they said it. I know they said it. Well, unfortunately, if it's not being presented live in the courtroom, just what you've heard someone say, you can't say again. And when you have a trained trial lawyer, as soon as a witness says, but Joe told me, they're going to pop up and eject, and that evidence that you thought you were going to get in is not coming in because there's a veracity element there. The court has to be able to judge the truthfulness of what's being admitted from the witness stand, and you can't talk about someone who's not there.
And thank you. We have a live question. When trying to divide property, the caller paid all the bills, paid the mortgage. He can prove that he did, and the mom was a stay-at-home wife for 2 out of 5 years. The question is, will she still get half the house? Yes. They're not related. You just described, you put two chess moves together. You talked about a pawn and a knight. They're just different. So dividing property is property, like who owns it. You don't lose ownership because you were a stay-at-home mom or gain ownership because you worked. So those are just two different things. In fact, what you're more describing is, will you have to pay alimony on those facts? Because if you have a stay-at-home mom and you've worked, and depending on how old your children are, and depending on what their ability to earn is, you may be looking at maintaining the status quo and having to pay alimony. So I would spend some time looking into alimony. If you have questions about your real estate, I don't know what the ownership is. Was it separate property? Did you have it prior to marriage? Was it her separate property? Did you buy it jointly? Did you get gifted funds? I mean, there are other things that you can talk about to try to change how the division is. It's just simply not whether or not the person stayed home. It's just different. You need to ask different questions to get to maybe to the conclusion that you're looking for. So call us and we can definitely talk about it because they're good questions.
I think that's actually a really good segue into another bit of evidence. It's expert testimony. That's something that you're going to see a whole bunch. That can come from anything from a child family investigator report when you've got children involved in the case, to the next step, a PRE, up to what you were kind of asking about with the alimony, is I'm forgetting the term right now for it, but someone who examines, what someone's level of education is, what the job market is.
Vocational evaluation.
Vocational expert. Yeah, thank you, April. But yeah, that as well. That's a report. The vocational expert's hired and they'll generate a report that says, you've not been working for this long, but previously you worked and this is what you were earning. This is your experience. These are the degrees you have. This is what the current job market is. So this is what I'm going to equate your income, or what I would suggest your income be equated to when calculating an alimony payment.
That's a very good point.
Yeah, and even if there's, sorry.
No,
yeah, and even if you don't have the experience or anything, courts will often equate the non-working spouse to minimum wage. So that I think it's just under $30,000 a year. So that's something that they'll use if someone doesn't have an education or a lot of experience who is going to be coming back to the workforce after having raised children. That's something we pretty often see.
And if someone has an ability to earn, the court can't make you go to work, but they can take the vocational expert that we'll just talk about, use that number, plug it in as if you worked all day, every day, and that's what your support orders would be based on. So that's a very important expert and piece of evidence. Here's one. Can recordings of your kids saying they don't want to live with the other parent be evidence in a custody battle? Who wants to take that one?
I can, only because I kind of saw that question and then brought it up as part of my last answer. So again, it cuts both ways, right? And the important thing to remember is that we do have ways of, depending on the age of your children, right, getting their opinions and their thoughts about, where they want to live and who they want to live with most of the time. We have experts, right, who can prepare a report, they can talk to the kids, they can write a report for the court, and that sort of evidence is admissible, right? And so that's the way that we really encourage people to go about it versus, recording the kids and then submitting that to the court. Because for one thing, on its face, it's hearsay. So your kids are not coming to testify in court, right? And a hearsay is any out of court statement made by anybody, right? There are exceptions and when statements can come in during a court hearing, but your kids are not going to be testifying witnesses at a hearing or any kind of court proceeding. So anything that they say outside of court is inherently on its face considered hearsay. There are a few little exceptions to that rule, but the assumption going in should be that those recordings are not coming in. And so even taking them or, potentially submitting them to the court for the judge to consider is probably going to cut against you in the long run, and it's not going to be admissible at any kind of hearing. But we do have ways that, we can present what your kids' desires are and who they want to live with. So that's probably the better way and the more appropriate way to go, because these experts are literally trained in how to deal with these high conflict situations and kids who are in the middle of sort of a high conflict situation.
Right. Now, there are exceptions to hearsay. And so the recording could meet an exception to the hearsay. You could get around it. I would say, let your lawyers see what you have, and then you guys can talk about what's next, the best to do. What I wouldn't do is rush in without a lawyer and just start playing all the stuff you have. That's where, you know, without finesse and strategy, it could really work against you.
Yeah,
But
if I may piggyback on that, you know, one of the things to really remember is let your lawyer be the gatekeeper of the information and help you decide what is evidence. Bring it to us. Let us sift through it for you and with you and determine what the best pieces are. Because one of the things that's always a little scary as a lawyer is a client having evidence that they didn't share with you. So you don't know if you can use it or not. So the safe thing to do is always give us all the evidence, give us everything, and we'll help you sort through it and decide what's best for you. And as April mentioned, playing chess, pick the evidence that fits with our strategy so
yeah,
we can help you get what you want.
you could accidentally have reported an excited utterance, something that was happening as it was happening, and the court, the truth, the veracity and truthfulness of it, the rules of evidence have already decided that it's something that is happening in the moment is more likely to be true than if I went home, I thought about it, I came back, and then I told you. When I'm going,
Absolutely.
it's probably truthful. So there are exceptions, but it's like not reading the chess rules and trying to play. You really can't guess at it. It is not common sense. Okay, let's take some live questions. What is your long? Do old criminal charges affect parenting rights with custody? Well, I'll ask my public defender.
Yeah, absolutely. And I'm going to give the typical lawyer response of it depends. And it depends because there are a lot of different factors that a court has to consider when they're looking at what parenting time should look like, how much time children should spend with each respective parent, right? So one of the things that a court can take into account is previous criminal history or previous criminal convictions, or even if you haven't been convicted and you were just charged, or if you successfully completed probation. A court can take all of that into account. But the starting presumption in Colorado is that each parent should get 50-50 parenting time visitation, right? That's the starting point, unless there's a reason why that doesn't work or can't work. And that's when these sort of factors come into play. And so in terms of criminal convictions, I would absolutely say that something like domestic violence is going to weigh heavier in the court's mind, especially domestic violence, where the children were either in the home, they witnessed the event, and it's against the alleged victim is the mother or the mother of the children, essentially. But things that can sort of weigh against that is, how long ago was it? How long ago was this conviction? What have you done since then to, receive treatment, receive counseling, receive therapy, receive substance abuse? What have you done to sort of take the steps to make sure something like that doesn't happen again? And even if the criminal conviction is recent, it doesn't mean that you don't get to see your kids or, that you're not entitled to any parenting time. The courts in Colorado have rarely said that, a parent has completely given up their parenting rights or their visitation, even with very, very serious criminal convictions. And so just because it is so dependent on so many factors, talk to your attorney about that. Let us look at, what happened in the prior criminal case, and we can tell you, facts specifically based on your case, how we think that we can use that to our advantage.
Thank you. That's great. Anybody want to add on to that? All right.
I think one of the things about prior criminal convictions, and Morgan led to it, is there are different types of crimes, right? For example, if you just had a DWI 10 years ago because you left the Broncos game and had one too many beers, that's one thing. But if you had a prior criminal conviction that involved, say, you driving under the influence and you had a child in the car with you, that's a much bigger deal. And so the court can look at can look at those old convictions and view it as whether or not this human is making good choices that might bad choices that might negatively impact their parenting.
Good point. But we like a feel-good comeback story. Just, the point is you can be that, you could have been that person, and then we can use evidence to show the court that you're not that person anymore. You wouldn't do that. You've taken parenting classes, you've had coaching or therapy, you've taken steps to show the court that that's just not who you are. Now, if the court doesn't quite believe you, they can let you have parenting and then put things in place like breathalyzers and have you do drop in checks, so whiz quiz type checks. So there are ways to get around this, to get to the next best place for yourself, and you're not stuck where you were. You just, again, need to be strategic and thoughtful about how you gather that evidence and show the court that you're a good, safe place for your child to be with. All right. Here's a wife reduced her hours at work. So this is the vocational expert type question, an impute income type question. There's the allegation that the wife is voluntarily underemployed because she reduced her hours. She had been the primary earner, but the wrinkle is she is getting an advanced degree. So she's in school to get an advanced degree that will take another year. Completely changes the facts. Who wants to jump in on that? Will?
Yeah, I can jump in. To address one of the parties pursuing an advanced degree or becoming a student, that's something a court will take into account and not equate an income for that person. If they see that they are a full-time student, if they're part-time, they'll look into a part-time job and equate a partial salary to them. But if they're a full-time student trying to get a degree, and it's something that the court actually is convinced that it's going to help their career or advance something, not just a way to kind of cheat and say, oh no, I don't have income now, I want some alimony, but is actually pursuing a degree. They're not going to equate an income. So that's something that's useful for the attorneys to know that that's happening. It's something we can definitely help you with. That's going to be very situational, time to time. You know, if it's 1 year where someone's going to be getting a degree, afterwards they're going to be making a lot more money, an order can be entered right away about child support and alimony based off that no income while they're a student. But you can always come back and try to modify that support order a year later when that spouse is working again. So that's also useful to know. It might hurt you at the time initially in the case, but later on it can always be modified once they are earning that full salary again later on.
Thank you.
I guess I
Anybody want
didn't
to
speak to the, oh, sorry. I guess I didn't speak to the reduction in income right there. Again, that's a vocational expert. You're gonna want to hire to say, you know, they're underemployed, they could be earning more. But it's also a cost benefit analysis. With experts comes a price tag. They're doing their job, they're earning their money. There's a cost that's associated with that report being generated. So if the report is going to be, I'm not sure the exact cost, it can range, $1,000 to a couple $1,000 sometimes. And if that cost is going to be higher than what they maybe decrease in what their income is, and is not going to aid in, the support you're going to be getting, that's a cost benefit analysis. It might not be worthwhile. So if it's a very small change, unfortunately, that's sometimes how it is. If it's, a couple $1,000s a year less, it might not be worth it. If it's a big change because of that, a vocational expert's definitely going to be worth it. And that's going to be evidence you're really going to want to present to the judge.
Thank you. All right, let's try to get another couple questions. My soon-to-be ex-spouse takes the kids to schools and doctor visits, says when we'll assume it's a mom says, I can help. The dad says, or the other mom says, no, don't help. Should this person insist on doing these things so they can get more parenting post-decree? So it sounds like it's two married parents. One parent does more of the transporting of the children and taking the children to school and doesn't let the other parent participate when they ask. Billy.
Yeah, this comes up often, and I'll say that oftentimes parents have to divide and conquer, right? You have different roles in your relationship. One person may have more flexibility in their work hours, things like that. So I wouldn't say that you need to insist on being the person that takes them to school or takes them to the doctor's appointments. But on the other hand, it is important to know things like the names of the children's doctors, know the names of the children's teachers, know what size clothes they wear, know about your children in general. Just because you didn't take them to school and drop them off at school doesn't mean you're not participating.
Thank you. All right. I have a person asking, the wife has the school account logins and they're trying to coordinate activities and childcare and household bills. Will the fact that the wife does most of the scheduling and grocery shopping be something that could be used against them in court when it comes time for custody? We are getting different versions of the same question over and over because we get different versions of the same question over and over. Morgan, you want to jump in and give another angle on this?
Sure. I think kind of similar to what Billy said, right? Of course, your homes are going to look different, right? When you're dividing a 2-parent household into 2 1-parent households, right? At that point, you guys are going to have to sort of, there is a lot of elements, right, that you'll still have to work together on, right? But, one person is then going to have to do the grocery shopping, right? And then the other person's going to have to do the grocery shopping for their own house. And so, yeah, it's going to take an adjustment. It's going to take, cooperation and an exchange of, what are all these various things, right? If dad is not the one who traditionally takes the kids to doctor's appointments because mom's schedule is more flexible, well, that's okay. Maybe mom's schedule continues to be more flexible and she can still take the kids to the doctor, but dad at least has all that information, right? Has the ability to contact the doctors if they need to, or when the kiddos are with dad, if he needs to call the doctor, he knows who he's calling, right? So everything is going to look different, right? On the other side of a child custody case or a divorce case. It really just takes that cooperation and the courts recognize and the more parents recognize that things are going to change. It's going to require an adjustment. And the more that parties are willing to work together and sort of take on those new roles, the better it's going to be for everybody involved and ultimately the kiddos.
Thank you. We have a question about at the time of divorce, what value does the court use for your accounts, for your retirement accounts, your bank statements? Do they use the value at the time of separation? Do they use the value of your retirement and bank accounts at the time of divorce? Bill?
Yeah, that's a great question. It comes up a lot. The value of the accounts that matter the most are when the divorce is final. Markets are very volatile, whether it's the housing market or the stock market. And so one of the things that we do at Jones Law Firm that I think is really critical is we update those financials as we move through the case. We have to file the financials in the beginning. We also update the financials before mediation. And then ultimately, if it goes past that to a permanent orders hearing, we update them right before the hearing, because what matters most to the court is what is the value at the moment that you're getting divorced and that the court is issuing the orders.
Thank you. I have a Spanish-speaking client, a Spanish question. We actually have a whole Spanish paralegal lawyer team, and they are not on the call today. It looks like the question says that the wife, the husband took the car to Mexico. The car is still there. The wife wants to know if she can get the car signed over to her. I cannot tell from the question if there are court orders yet, because you said that something's not signed. I don't know if it's the court order, if the court orders are signed, but your husband hasn't signed the transfer deed that the court told him to sign, then you can do a Rule 70 motion, which is where you have the court clerk can sign the transfer deed as if it were your husband or some version of that. So we have that in our arsenal. So give us a call and we can get our Spanish-speaking team to helping you. Okay, we are a few minutes over, so that is our last question for today. Hey, thanks, team. This was fun. This is a different way to help. So have a good time. We'll see you next time. Or not a good time, but call us and we'll help you. And we'll see you next time. Thanks. Bye.
Awesome. Thank you all.
Thank you.
Bye. Thank you for joining us for this webinar. If you or someone you know would benefit from watching a recording of this webinar or any of our other webinars, They can be found at denverdivorceattorneys.com. Thank you, and keep a lookout for future live webinars, and I hope to see you again.